I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute and author of the column known as Rochelle's Daily Wire. We have another update for you on what's been happening in the last week or so in the U.S. Supreme Court. First off, we have a denial of certiorari in two creditors' rights cases. First off, they refused to review a case from the Second Circuit called Anderson. The Second Circuit had ruled that arbitration would not be enforced in a class action alleging a violation of the automatic stay. The court also declined to review a case coming from the Texas Supreme Court called Noble Energy. In that case, the Texas courts may well have misinterpreted federal bankruptcy law dealing with assumption of contracts, but the U.S. Supreme Court is not much in the business of reviewing state court judgments that misinterpret non-constitutional federal law. Next, I want to mention the Abdusky case, where certiorari already has been granted. I'm guessing that case will probably be argued in December or January. It has to do with a very important question for states where there is non-judicial foreclosure. The court will tell us in their decision on that case whether or not the Federal Fair Debt Collection Practices Act applies to non-judicial foreclosure. Next, we have certiorari petitions in a couple of cases I think that are very attractive for review by the Supreme Court. First, we have Lorenzen versus Taggart out of the Ninth Circuit. In that case, the Ninth Circuit held that good faith is a defense, get that, a defense to an alleged violation of the automatic stay. Counsel for that debtor in that case promises that he will have filed his certiorari petition by the time you watch this. Also, we have the Technology case that is making its way toward conference by the justices, perhaps in late October or November. Technology comes from the First Circuit, and that deals with a very important commercial question of whether or not the rejection of a trademark license bars the licensee from continued use of the trademark. You can read more about these cases in the Supreme Court in an article on my column on October the 2nd. Otherwise, I urge you to pay attention to the ABI website, and if you haven't already, sign up for my column and it will be sent to you automatically every day at about 8 o'clock Eastern Time until this time next week. And this is Bill Rochelle signing off and saying, be well, don't work too hard, come home before 8 o'clock every night, and remember, your children are young only once. Thank you and good day.